Way back. Even though it's been like 1 week since we've recorded.
Feels like it's been forever.
And didn't we record like 2 nights in a row? Like.
Yeah. Yeah.
Oh my goodness. That's great.
Yeah.
Well,
hey guys.
It's good to be back.
Good to be back.
I'm glad to see you, Brett. I missed you.
I'm good.
Did you have a good Thanksgiving?
You too. I had a great Thanksgiving. It was fantastic.
You guys stayed put in your house, right?
Yeah, we did.
Oh, that's good.
We
drove 13 hours each way to spend Thanksgiving with friends and family, and I'm happy to report only 2 of my 3 kids threw up. So
nice.
There's a favorite child right now. I'm not going to say which one it is.
2 out of 3 ain't bad.
Who did not throw up.
You ready to start recording?
I guess so. Let me start. It's been so long, I forgot that we record. Okay. Ready?
Sure.
3, 2, 1, record.
I mean, it's really just about talking to you, Alice. That's a fake.
Well, no, I did. I missed you a lot because, like, when you travel with your children, it's like 24/7, man. There's like no break, no school, nothing.
Mm-hmm. That's true.
But it was okay. My proudest moment. It was like hour 2 of the ride. Hour 2 of like 26 hours of driving total, and all of a sudden, the 6-year-old was like, "I'm gonna throw up," and I was like, "No!" And I stuck. I had a bag and I dumped everything out of it. I stuck it under him and I caught it.
Oh, wow. That's impressive.
It may be the most accomplished I've ever been in my life that I caught it midstream.
I was talking to Allison about this, how the best thing about having kids is like the minor things feel like such massive accomplishments.
I have not been prouder. Like the diplomas I have on my wall, I traded in because I caught that midstream, which you know what that means? We didn't have to spend the next 24 hours of car ride with the smell of.
So important.
You know? Because you can't get that stuff out.
No, you really can't.
Oh my gosh.
All right. We ready?
Yes.
I mean, it's a legal brief, so you have.
I know. I
got to carry the burden.
I think I've already used this descriptor, so let me see if I can come up with another one. It matters
still true
to me.
Today.
Huh?
It's still true today.
Let me just use my brain for a second. Yeah, that's not a word. But what if I made it one?
You do whatever, Alice.
Okay. I'm ready.
All words started off as not words at some point.
That's one way to say it. Okay. We're going to cover it all today, right?
We're going to try.
All right. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my transcriptional co-host, Brett.
Oh, transcriptional. I think that works. That's a real word, right?
Sure. That is a real word. Transcriptorial is not, which is what I was thinking of it first.
I actually like that word better, but it's fine.
Doesn't it kind of sound like a conspiracy? Like, how transcriptorial of you to say that.
There you go. I love it.
But transcriptional, I think more of a concert rather than the transcribing of transcripts of what happens in a courtroom or in chambers.
Very important.
Maybe this is enough hints for you guys to know what we're talking about. And that is, yes, there is another Delphi update. We shouldn't call them updates. They should just be called dates because they're not up of anything. Yeah. Nothing's happened. But whenever anything happens in the Delphi case, people kind of lose their minds and they act as if the world is falling apart or this is the most, earth-shattering thing that has happened. And yes, a couple of things have happened. A transcript of the in-chambers conversation with former counsel for Richard Allen and Judge Gull, as well as the prosecution, was released, as well as 2 filings, one by relator Judge Gull and one by the state in response to the writ of mandamus that has been filed on behalf of former counsel of Richard Allen to be reinstated as his counsel. If your head is swimming now and you haven't been following this, we'll try to walk you through it, but that's what we're doing today.
And I think it's important to note this is all a sideshow. I mean, The case is moving along slower than it should. This is all a distraction. Hopefully, one day it will be resolved one way or the other, and we can stop with this stuff. I do wish there's a part of me that wishes this case wasn't as famous as it is, so people weren't following every single development like it's the end of the world. It is true that this case is more complicated than most, and certainly weirder things have happened in it than you typically see. But as we said before, every trial is its own animal, and there will be some weirdness. Mandamus is unusual, but it does happen. So it's not the end of the world. And we're here to try and explain the things that are happening to you. The problem we've been operating in a lot is sort of a fog. We don't actually know so much about this case. It's one of the things we've complained about a lot since the very beginning. And I think has sort of infected this case in a way that it doesn't really affect other cases, and it continues to affect it. And what's been interesting about what's happened over the last month or so is after Rosie and Baldwin were removed, they essentially, I mean, I hate to call it leaking since we're talking about leaking, but they keep filing things that are uncovering things that were previously sealed. And we've talked about this, how it's not necessarily a bad thing that those things are out in the public. It would be nice if it was done through an actual sort of judicial process, not through them just filing things attached to documents that they shouldn't be filing. In this instance, this transcript has come out sort of the way it's supposed to, but at their behest. And what's been interesting is every time they release something, it gets worse for them because every time we learn more about the facts, so much of what we've been told and what we've been led to believe is just undermined. I remember when this all started, the big thing was this was a total shock to them. This bizarre in chambers meeting. Would they even have something like that? It was a complete ambush. They had no idea what was coming. And the more we learn, the more we see none of that is true.
Absolutely. A lot of this is kind of the definition of screaming into the void. Like the purpose is to be yelling about the process and not actually want what is to be released. Because every time you're right, Brett, whether it's the transcript that we're going to go through, which is, by the way, pretty much exactly what we thought happened in chambers, whether it's the transcript or more detail about the communications between Judge Gull and counsel regarding the leak and the investigation, the more it looks bad for the defense in the sense of they are not uncovering these releases have not uncovered some bombshell gotcha from the prosecution or the judge with the defense. Rather, it's been pretty much as we suspected. Now, the problem is none of this has really been public. And so when you have a vacuum of information, guess what rushes in, right? Nothing's going to stay a vacuum. There's going to be conspiracies and speculation rushing in. And that's what we've seen in this case. And we've been critical of the judge of being of doing a lot of things that are not on the docket. And we truly think, you know, we think that she's been doing it, and I think the transcript is going to bear this out, that she's done this to try to save face for the defense counsel, as professionals who have careers outside of this case. But as we've seen, this case is not your regular case, and it's come to bite her again and again. But with that said, last week has it been a whole week now, Brett?
It's been a
Last week,
whole
right
week.
before right before Thanksgiving, and I really did try to jump on a live, but like I was hours away from a 13-hour drive, and I was like, I might not make the 13-hour drive if we get on a live. So sorry we had to wait a whole week to talk about the transcript. But as you all may remember, back in the middle of October, there was supposed to be a hearing about the leak of crime scene photos of Abby and Libby to figure out where that leak came from. But before that very anticipated hearing, where a lot of people waited in line, it was going to be a broadcast. People were sitting in the courtroom. A lot of our friends were sitting in the courtroom waiting to see what happened. Where did this leak come from? There was first an in chambers meeting with the judge, the prosecution, and the two former defense counsel for Richard Allen, where what was discussed was not transcribed by a court reporter per se, but there was a recording of that conversation, which then had to be transcribed and released. And so, what was released last week was a transcription of a recording of what happened. I could keep going. I want to see if you want to talk about the recording. Okay, so the thing with the recording,
you're right. I don't have a whole lot to add.
I do want to note about the recording because a lot of people I've seen have been like, you would know if a court reporter was in there. So by the way, especially in some more minor hearings, think about a courtroom. A lot of cases are flowing through there. I don't know Judge Gull's caseload, but a typical judge can have anywhere from hundreds to thousands, most likely thousands, if not tens of thousands of cases. And all of those cases could have lots of hearings. And in the life of a case, there can be very substantive hearings, like challenging the search warrant or challenging your basis for the indictment. Those sorts of things are pretty meaty case dispositive hearings where likely there will be a physical court reporter who comes with a court transcription service, comes with their, it looks like a little keyboard, and they set up in front of the judge's stand and types as you're talking what you see on TV. And that person will say things like, "Counsel, can you please slow down? I have to write down everything you're saying." That's a court reporter. But those things cost money and time, and there are limited resources because you physically need a person who is trained in court transcription to be in the courtroom in order to do that job. So, because there are so many hearings that happen in these tens of thousands of cases, many times hearings will be recorded. Brett, really the majority of our smaller cases that we've done are going to be a recording. And there's no transcription because, again, that takes money unless someone requests a transcript and there's a cost associated with it. And that appears to be what happened here. Even though there was not a court reporter that I know of, it's not completely clear to me from the transcription, but I believe there was a recorder and someone pressed record. And so there was a record of what was discussed, but the physical transcript did not exist until it was ordered to be transcribed, which it was in this case. And you can tell because there's a lot of uh-huhs and nuh-uhs, those sorts of things, which if a court reporter were actually transcribing at the time, you'll also hear this on TV a lot. Counsel or witness, I'm going to need you to give me a yes or no answer. And that's because the nuh-uh and the yuh-huh all look the same on paper when you don't give a verbal yes or no answer. So this particular transcript, you see a lot of the uh-huh and the nuh-uh, which doesn't typically happen when you have a court reporter in the room. And by the way, that's totally normal to have something recorded.
Yeah, I think there had been some rumors out there that there was no recording or that the recording had malfunctioned or something along those lines. Turns out that wasn't true, and they were able to transcribe it, and eventually it was released. I don't really know why. I don't know. I mean, look, I don't know why anything's secret in this case, to be honest with you. I don't know why it took a while for this to be, it had to be transcribed, which takes some time. But there was also this notion of the judge had marked it as sealed or something along those lines, like everything else in this case. And so it took a little longer for it to come out than maybe we thought it would. And I don't know. It's hard to get in the head of what exactly the defense is doing. There was a lot of the way they positioned this that they didn't ever think this would come out, or maybe they believed that there was some sort of malfunction in the recording, because there was just this feeling like they were setting it up for this to have not been transcribed. I mean, just as reading between the lines and how it was presented in some of the filings that this wouldn't be transcribed, but it was, and we have it, and we're going to go through it.
Let me pull it up. I got too excited talking about it that I forgot to pull it up. So excited. Okay, it's pulled up.
And we're also going to talk about what we've seen recently, which are the responses to the mandamus, the second mandamus petition, both from the state of Indiana and from the judge. We'll talk pretty briefly about that because they say the same thing and they essentially repeat what we said in one of our earlier legal briefs. But we'll talk briefly about that after we go through sort of what happened at the hearing.
Right. And this is a relatively short meeting. I think the entire transcript is 27 pages, something like that, which if you've ever done transcription is just not a very long. I think there's probably times in here. It's just not a very long hearing. And that's important here too, because I've heard people kind of speculate that there was this long drawn out meeting where so much stuff was happening and all this evidence was being presented, in the dark of night where the public couldn't see. And we can see everything that they're talking about here. And it's pretty straightforward. And basically it starts with the prosecutor saying we're ready to present the evidence. And you can see that the former defense counsel do come in not anticipating that by the end of this meeting, they're going to withdraw. They come in, well, they did file that brief, remember? They
Also,
filed
you
the
got
brief.
what I sent you on this, right?
No.
Okay. Well, I just sent it to you again.
Oh, I should probably.
It's been a while, folks.
It's been a while. And also,
and let me just say, I take issue with what Alice just said. I hate to disagree with Alice.
oh no, you can disagree with everything I say.
I think they came in really nervous that they were about to be removed. And I feel like just even in the way they talked about some of the other issues,
If you
there
would
was
let
like
me
some
finish,
nerves
Brett. No,
there.
I'm just kidding.
There were some nerves there. So
I agree with you on that point. They were acting as if were not going to withdraw because they were nervous. And you know this because they never stopped talking. They talk for the first, however, I mean, they are just talking, and the judge is doing all the not really giving much. And they're acting like that because when you're in trouble, and you just talk about everything but what you're in trouble about, that's kind of the sense that I get. They are motor mouths. A lot of information, a lot of word vomit is coming. Sorry, I'm thinking about vomit. A lot of word vomit is happening. And you can see that because it's kind of stream of consciousness and they're talking really quickly, acting as if they have nothing to be sorry about. That was my point. So I think we actually agree, Brett, that that's the way they're acting. I think they do that because they just filed a motion, or not a motion, I'm sorry, filing a notice, a document with the court with their own counsel defending everything that they did and why they shouldn't be removed. And they did not come in kind of with their hat between their hands saying mea culpa. It was quite the opposite. They did not kind of own up to everything they did at the start of this meeting.
And when you file something like that, and we're going to talk more about this, but when you file something like that, when you hire a lawyer, you're not doing that just out of anticipation of what might happen. You clearly have some real indication that this is an issue. It's not just, oh, well, maybe we should hire a lawyer. Oh, maybe we should file something saying you shouldn't remove us. Clearly, they knew when they walked through the door that this was something that was going to happen. And that's probably one reason why we had this whole meeting in chambers in the first place. It's not an accident that happened.
So the first thing is, why did they have this meeting in the judge's chambers? Because remember, there was a hearing and there were a lot of people waiting out in the gallery for this hearing to start. So why hold up everyone and meet beforehand if this exact same meeting or the substance of it was going to happen in public? Well, here's what's important and what we learned from the transcript. This meeting wasn't some attempt by Judge Gull to hide what was about to happen, because it wasn't even at the judge's request. This meeting happened at the request of former defense counsel Brad Rosie. He said in the transcript, quote, "Well, I'm the one that kind of asked to huddle up. So if you want me to lead or if you want me to say some things, I'm okay with whatever approach you want to take here." I mean, it is plain as day. He himself starts talking and says, "We're all here today in this meeting because of me." Now, this, by the way, is completely contrary to what the mandamus petition says. Before this transcript, we actually didn't know, and this is why we've said several times that it gets worse for the defense as more information comes out. Because before this transcript, we just had their mandamus petition to go by. In that mandamus petition, it claims that Richard Allen was completely unaware of this meeting, that it would occur, and it was an ambush. Richard Allen is represented by his attorney, and his attorney himself says, "I called this meeting."
Yeah, there's some real sleight of hand that happens at times in the mandamus petition because, Richard Allen and his attorneys, for the purposes of this trial, are sort of one and the same. And maybe Richard Allen didn't know that his attorneys had asked for this, but the way it's presented is this was an ambush. Like the judge called him back there and they thought maybe we're going to talk about, which side of the courtroom we should sit on. And all of a sudden they're talking about getting removed. And that's obviously not what happened. And Rosie leads the way by saying, yeah, I'm the one who kind of called this. And then once the judge is basically like, okay, you want to lead, you can lead. Then we get to this question of were they ambushed? And no. And we know that because Rosie then explains exactly why they wanted to have this meeting in chambers. He says, it's probably obvious that the tension from our side is coming, from the words disqualification that were murmured. I love the use of the word murmured. It was like the judge and the prosecution just sort of like whispered it into the phone where they could barely hear it in the phone conference we had a couple weeks ago. And this confirms something that we knew from prior releases, once again, by the defense. And I don't know if they just thought since it was buried in 150 pages of disclosure or whatever, maybe people wouldn't notice this, but it became fairly obvious fairly quickly that for weeks, the judge and the prosecution and the defense had been discussing what the consequences would be for both the release of these photos and some other issues we're going to talk about earlier, and that disqualification, which is what happens when a lawyer is removed from a case, they are disqualified from the case, had come up weeks before the meeting. And it makes perfect sense. As we said, this is the reason that Baldwin hired a lawyer, and it's the reason he filed a memorandum opposing disqualification. He knew this was an issue that would arise at this hearing, and Rosie just makes that even clearer in this meeting in chambers.
So why not do this in public at the hearing then? Well, because again, from the transcript, we find out it's the defense that didn't want it to be in public. Quoting from the transcript, we have, I guess if I have a concern today, it's that, we're going to go out on the kind of in the public, so to speak, in the courtroom on the record and have a discussion about an ongoing investigation. And I have no problem. I mean, I don't have any problem talking about this stuff privately on the record in in an ex parte type confidential hearing. So, I mean, this is Rosie saying, whoa, this is not going to be good. We shouldn't be talking about these things out in the public. I'm not scared. Let's talk about this behind closed doors, exactly what's happening here. And that's why he had called this huddle up.
And he even asked for it to be ex parte, which means the prosecution wouldn't even be there. And there are times where you have that. Like if the attorney and the client are basically irreconcilable differences, like they're getting a divorce. If you have a situation like that and they need to explain that to a judge, that's an appropriate time for the prosecution to step out because we're not really interested in that. We don't want to know and we shouldn't know. But in a situation like this, where you have something where protective orders are being violated, stuff's being leaked, it's silly to think that you would have a situation where the prosecution wouldn't even be there. And what's interesting is people complain, or they did complain before we knew that the prosecution in fact did ask for it, that if the prosecution wanted them removed, they could have said something, they could have moved for that. And here you have Rosie saying, we don't even want the prosecution involved. If we discuss this at all, we want it to be in secret in a private hearing where it'll just be us and the judge, and that's it. No prosecutor allowed.
Right. And so now this whole ambush idea didn't get made up at the writ of mandamus stage, because even though Rosie just said that he knows what's about to come and, he doesn't want this happening out in public, they do complain about being ambushed in this meeting. So there is some genesis to their argument here, even though there is their very own words show that this is not an ambush. So both Rosie and Baldwin repeatedly talk about due process in this meeting and the fact that they've received no contempt citation or motions to disqualify. Now, this request for some sort of formal filing alleging they've acted improperly is inconsistent with their own desire to have all of this handled privately. So, yes, there's been no formal motion to disqualify or a contempt citation. By the way, you don't want that as an attorney because then that's on the public record forever and ever and ever. There's no such thing as wiping the record clean. Even when you misfile something on the docket, everything is a record of what happened. You don't erase things on a docket. And so once something like that is filed on a public docket, it's there forever. And they themselves have said, we don't want this to be public. Yet they're kind of arguing and saying we haven't been given due process because there's no formal finding against them. It's kind of a like damned if you do, damned if you don't situation that they're creating for Judge Gull.
And they're in a really bad place here. because on the one hand, they don't want this to be public. They want it to be handled privately. But on the other hand, they also see where this is going, and they're trying to buy time. They're trying to sort of point out things that should have happened that didn't happen in the hopes that the judge will say, you're right. We should do this more formally. We should, we'll schedule a hearing in a month or whatever. I mean, they're really trying to buy time here in the hopes that maybe emotions will fade. I mean, I don't know. I mean, just they don't want this to happen right now, because I think they know if this happens right now, they're gonna have an issue. And I think you see that, and that's why there's the conflict. I mean, people might wonder, like, why would they say two opposing things? Well, they're just thinking on their feet at this point, right? I mean, they're just throwing stuff out there to try and save their skin.
Right. And so this whole like mention of due process and kind of how there's been nothing formal, it's all strategic because Baldwin actually admits the seriousness of what happened. And I'm going to read directly from the transcript for you. I mean, we're still waiting to try this case in January, and I'm willing to, we've made changes at my office that will prevent this from ever happening again. And we can take directives from the court. We can, we're locking down every single thing on Delphi. It's in a dedicated room. We put locks on our conference rooms or the war room where this guy my friend went in and did this without my knowledge. And no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single solitary second ever again. So, I'm hoping that that can be something that the court, can say, all right, that's fine. And then let's get on with this trial. But I'll shut up now. I mean, I just read it word for word to you. There is a clear recognition of how serious this is. He admits yet again that it was a leak from his office, that he did not keep these documents that are subject to a confidentiality order under lock and key. He says it himself. He says, oh, now I have a specific room for it. Now I'm going to lock it. He didn't say it was locked. I did take precautions. My friend tricked me. None of that is here. There's none of that happening. It was his fault. And he says it all here in this admission.
And this just goes back to something that I've been asking for people, even people who believe that the judge went too far, to acknowledge. And that's that these guys, Baldwin in this circumstance in particular, really messed up. They really messed up. They made a huge mistake. They were negligent. They were grossly negligent. This never should have happened. I mean, this should be something everybody agrees on. Baldwin admits it. Baldwin acknowledges it. He gets it. And he sort of throws himself on the mercy of the court and says, look, I made a terrible mistake. I'm going to take steps to avoid this. What's interesting is, in a minute, we're going to talk about Rosie. Rosie takes the exact opposite approach. So you have Baldwin, who's like, this is super serious. I'm so sorry. I'll never let it happen again. And then we'll see what Rosie says in a minute.
So the prosecution tells what it's prepared to do. So up until this point in the transcript, we're reading it to you. So you could save yourself. I have no idea. This is going to be a long episode. You could just save yourself and go read 29 pages and it'll be a lot faster. But the prosecution tells what it's prepared to do. The prosecution states that it has witnesses and exhibits, and the prosecution is prepared to go out into that courtroom to the public hearing and provide this information to the defense, even if it does harm the investigation into the leak. And the prosecution explains that it has reason to believe that, quote, the leak is not just a one-time leak. The evidence that we have shows it's an ongoing leak. However, it's being done, and it's just what's next. Okay, this is very interesting because if this is true, Baldwin not only lied in his filings with the court, he lied in a statement that he gave to law enforcement about this being a one-time thing. And this is very interesting because, yes, you're right. Typically, we tell you this all the time. Ongoing investigations, you don't want to talk about them in public because it could hamper your investigation unless there is a greater harm in place, right? And in this case, it's that the leak could continue. It's already caused immense harm, not only to the victims, to the families, to the case, to a potential for an impartial jury, but also the fact that someone ended their life potentially tied to this leak. So it's very serious. And that's why the prosecution says we take this so seriously. There is an ongoing harm. We are willing to risk hampering the investigation because we want to make sure that this harm doesn't continue.
And The one sort of thing that's still out there unanswered, and maybe we'll never know an answer to it, is whether the prosecution is right about this. Whether the prosecution is right that Baldwin was in fact leaking continuously, not just the photos, but other information related to the case. The prosecution seems to think, in this transcript at least, that they have evidence of that, and that was something they were going to lay out in this hearing. I don't know if we'll ever know that. If that's true, if Baldwin did that, and if they can ever prove it, I mean, that's a crime. If he lied to law enforcement about that, that's a huge problem. It's a legal problem. It's an ethical problem. It's a problem for his bar license. All sorts of issues there, and I don't know if the prosecution is just going to drop that. The person who took the photographs has been arrested and charged with a misdemeanor. I mean, so I don't know what's next in that investigation. And let me just say, the fact that all this is ongoing is just yet more reason why Richard Allen would be better off if this circus moved on to the next town and he went on and had his trial. But we'll talk about that more in a second. So Rosie, at this point, Baldwin's thrown himself on the mercy of the court. And Baldwin, he's basically saying, yeah, I get it. All these horrible things. I'm trying to fix them. Rosie's like, I didn't do anything. I didn't have anything to do with this. And he says, in one of those, with all due respect moments, or, not to offend you, whenever you say that, you're going to say something disrespectful that offends somebody.
It's like saying bless your heart. You don't really want to bless their heart. You're saying like, I'm about to F you.
Right. And Rosie's like, I'm not distancing myself from Baldwin. And then he's going to spend the next few pages of the transcript distancing himself from Baldwin. He says, look, I didn't know anything about this. I know any of this was going on. He talks about due process again. He doesn't explain exactly what that means or how he thinks due process applies to him as an attorney in a case. He says he hadn't seen any of this information that the prosecution is planning on using against him in this hearing that's coming up. Though, as we've talked about before, that's not that unusual for the prosecution, as they said they would, to show them everything that's going to happen in the hearing. And then they just have to prepare for it. Like, it's not like a trial. You have these hearings. You really just have to have enough time to review something. And this can get, even in trials, this can happen. I'm thinking back to the Adnan Syed case. In that case, this is an aside, but when you have a prior statement of a witness, you have to turn that over to the defense. But the rule says you don't have to turn it over until they testify. So sometimes you have circumstances, and this happened in the Adnan Syed case, where Jay Wiles is going to testify. There's all these prior statements. They don't turn that over to the defense until like the day he testifies. And his attorney spends like her lunch hour reading the transcript of Jay Wiles' discussion with police officers when he was talking to them. And you just, I think most people in their minds will be blown by that. And they think, oh, they should have had that months before, so they should prepare. But that's, those are just the rules. The discovery rules are not as liberal as a lot of people think they are. But he's complaining about that. He's basically saying, look, I haven't had enough time. I mean, that's really what it's about. Once again, he wants to delay whatever's going to happen, whether it's a public hearing, private hearing, whatever's going to happen. He wants to delay this at some point until some point later on. And he even comes back to this should be a private hearing. We should do a private hearing later. And he tries to do the whole, well, you guys did it too. The prosecution did it too. And he argues there were some leaks in the investigation from the prosecution side. And so it's not just all us, you can't just punish us for this because they were doing it to defense.
Can I just say really quick? I've talked to a lot of judges for a lot of different hearings, and the kind of tone they take in this, not only the like nonstop talking, not waiting for the judge to ask a question and knowing their place, is something that is a little bit shocking, to be totally honest. I can't imagine talking like this when I've done something of this magnitude, nonstop, and not waiting for the judge to say something or just falling on my sword repeatedly. So this type of kind of immense ease they're taking with the judge is not typically how you talk to a judge. I will say that. And I think it's because they're fighting for their life, because this is potentially career ending.
And it only gets worse because Rosie is about to stick his foot as far down his throat as he possibly can do. Now, here's a tip out there for all of you who are young lawyers who I know listen to the show, and people who are in law school. If you're ever going to have a hearing and you know the judge really cares about something or is really mad at you about something, don't tell the judge that the thing they really care about and that they're really mad at you about doesn't matter. Do not tell them that. That is not the approach that's going to get you to where you want to be. But that's what Rosie does. He knows the judge is concerned about this, but he says, I don't care. I don't care about this leak at all. And that's not my interpretation. These are his words. And if the point here is, I'm going to say this maybe a little loosely, but forgive me. Once again, the whole not to insult you, don't take offense to this. I don't care. I don't care that all this stuff is out there because it's been out there for 5 or 6 years, which is factually incorrect, number one. But number two, just an amazing thing to say when you are fighting to stay in a case because of a leak that the judge is deeply concerned about. To say, I don't care is mind-blowing.
I'm covering my eyes right now because even though I read that before, I think I wiped it from my memory because I could not fathom someone saying that they did not care about the reason Baldwin hired an attorney, never happens, to defend himself in this terrible leak, not to even take the human side of what happened. You should care that the victim's crime scene photos are splashed out for the world to see, and that any shred of dignity or peace that the family might have is eviscerated because of this. And to have this sleight of hand and to recognize that you're about to say something unforgivable, which is why you start with forgive me. When you start with forgive me, it's probably unforgivable. To then say, I don't care. You could say so many things other than I don't care. You could say, this is a big deal, but not in the legal sense. It's a big deal for the victims, and I don't want to make slight of what has happened. But ultimately, there's no legal claim here, and there is no process that has been put in place that would allow for what the judge wants to do. That's the appropriate way to essentially put into perspective a problem that you want to minimize, not to say that you don't care, because clearly the judge cares. Clearly, there is an ongoing investigation into this. If it didn't matter, there would not be an investigation. There was a reason that this was a hearing where people lined up for, before the crack of dawn to come into, because a lot of people care, including the judge. And you know what? While you personally may not care about something, your job as an officer of the court is to care about the things the judge cares about. The judge has told you she cares, you better care. I don't care if you don't really care. Your job is to care about the things the judge cares for. And that's why when you have a hearing or when you talk to a judge, the one piece of advice everyone gives anybody is listen to the judge's questions and answer the judge's questions, because the judge's questions point to what the judge cares about. And the judge is the person who makes decisions. And if you choose to not answer her questions or not care and to flippantly say you don't care, that is as much of a middle finger as you could possibly give to a judge.
And I think the only you're trying to come up with a charitable way to interpret this very poorly worded thing, and words matter, as lawyers know, is he doesn't care. He's not going to claim there's some sort of, I'm making stuff up at this point, but he's not going to claim there's some sort of prejudice for the fact that these photographs are out there about the girls. Ordinarily, if you're a defense counsel, you wouldn't want murder scene photos out because they're prejudicial. You don't want the jury to see them until they have to, and you want to limit them as much as possible, have them in the cold, world of the court. I think that's the best you can do for him. And so he's trying to say, yeah, all this stuff got out, but it's not prejudicial to my client, so therefore it's not as big an issue as it might be in some other circumstance where it was terribly prejudicial. I think that's the best you can do.
So since I was so hard on that phrase, I'll now play devil's advocate and try to give the best interpretation. I think he's being honest because he doesn't think that this is ever going to be transcribed. He's really having a private conversation with the prosecution and the judge. And I think he truly doesn't care. And I think he doesn't care because he's lost complete perspective of the case. The reason he keeps talking about due process for himself, not for Richard Allen, is because he's lost sight of the fact that he represents Richard Allen, and all of his actions should be in representation in the interest of his client. He's lost interest and gotten lost in, you can fill in the blank, but whether it's that the world is watching him or that he's being applauded, in his own words, by defense counsel around the country for being the defense counsel that other defense counsel want to be, and that he's somehow this like TV character Matlock figure. I think he truly has lost sight of his duty to his client in this case. And no matter how big a particular case is, at the end of the day, even if it is a case that is being live streamed to the entire world, you have a duty to your client to do what is in the best interest of your client. And I think the bigness of this case got out of hand for him. And that's why he's able to say something so flippant. Because I think if he's able to come back down to earth and read those words, I do think he'd actually be appalled by it. I'd like to think that is the case. But I think in the moment, he'd lost sight of what it is, which, by the way, goes to the very point of what Judge Gull said. You guys can't represent him anymore because you aren't representing him. But there are some true things that come out of this transcript, and Baldwin then says the truest thing that anyone says in this entire hearing. He says, honestly, this is the worst, lowest point of my career right now because somebody did what they did to me, and that has nothing to do with Richard Allen. With Rosie sticking his foot in his mouth and saying he doesn't care, at least Baldwin, I imagine he has his head in his hands here, because that sentence at least says to me that he recognizes just how big of an F-up this is. And this is the first time we're really hearing Richard Allen's name, by the way. So after Rosie and Baldwin have said all of this, it really, even though we're just reading it on paper, it sounds very rushed. It sounds like they're breathless and they're talking on top of each other, a lot of you-knows, and they're trying to get everything out, right? They're fighting for their life. And at this point, the judge hasn't said much, but finally she lays it all out for them. And she lays it out in a way that, Brett, I think you and I said this is what we thought happened back there. She starts by agreeing with Rosie and Baldwin that she doesn't, quote, wish to air publicly to the world the concerns that I have about this matter. She discusses the motions that have been filed and how she's going to rule, and the fact she's still working through the Franks motion because of its length. And she notes that it's lots of exhibits, thousands of pages. Rosie takes a moment to blame the clerk or the judge, not really clear, for not filtering out the Franks motion from publicly view, as he was under the impression that nothing would be publicly filed until someone reviewed it. So there's kind of some discussion about it's not my fault it was publicly filed, which that was their whole point.
Which, by the way, yeah, there's no way. The idea, this is another instance, in my opinion, of Rosie just lying to the judge. There's no way they wrote that motion the way they wrote it, intending it never to be seen or not to be seen by the public until some far later date. No way.
And as lawyers who file things all the time, Brett, who makes the designation and clicks the under seal when you click the button to file?
Or stamp
the
it
attorney
on the top of the thing. Yeah.
On the thing. The attorney tells the clerk of the court because the default is everything is publicly filed. There's no, like, the clerk of the court or the clerks, whatever, or the judge, again, has hundreds, thousands, maybe tens of thousands of cases. They're not making individual designations of what should be confidential or not. That is up to the attorney. And that's why confidential orders in any case say very clearly it's up to the parties to determine what should be filed under seal and to have conversations. And the court doesn't act sua sponte here. So that's just not how it works, first of all. And it's a lie. But whatever. After clearing it up, and the reason I think he brings it up here is because the judge is clearly angry about all of this being out in public first. And so he's trying to distance himself from that and saying it was some mistake that is not his own. Better to say it was your own mistake, by the way. But that's not what happens here. So after clearing up that whole issue, the judge reads to the defense counsel what she has prepared to read in open court. Should that be necessary? And the statement is more than just about this leak. The judge notes that the defense misled her on their public intentions, leading to the public order. And here I'm going to read directly from the transcript. Judge Gull said, "This is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. Mr. McClelland filed a motion for gag order, and we were in chambers, and you assured me, gentlemen, quote, we don't want the media in our lives. We will not try this case in the media. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility. But it is that press release that prompted me to issue the order December 2nd, granting the gag order until further hearing. April 18th. Well, I'll stop there. So she had already prepared and knew what she was going to do, but she was previewing for Rosie and Baldwin what was about to happen in open court.
And she's pointing out something that's important. And this, once again, just I go back to what the defense has said and what they said in their mandamus. They continuously act like this is just about the leak. And even if the leak was wrong, this was so sudden and everything else. And the judge in the hearing is like, look, you've been doing things for a long time that have been problematic. And I've kind of let them slide. I have given you a lot of rope. And you've just continued to hang yourself. And the first thing you did is you sat here and you told me we're not going to try this in public. And then 2 weeks later, you're releasing this. And we all remember this press release, which did lead to the gag order. And that's not something that's going to get them removed. But what she's doing is sort of the long train of abuses part of this. And that's what she starts with is, hey, this has been going on for a year, that you've been doing things that are problematic.
So the court notes that the defense has attempted to there are a lot of things, and we now know this actually from the defense's own filings, that it's not just one thing that they did that led the judge to remove them. So we've talked about this misleading the court, the playing into the media, potential violations of their rules of professional responsibility, which every attorney is bound by. The court then notes that the defense has attempted to also represent Richard Allen in a civil suit at the same time that they're appointed counsel in a criminal matter. Quoting from the transcript, Judge Gull said, April 18th of this year, you filed a notice of tort claim against the Department of Correction. You stated in that notice that it was your intent to pursue, quote, our client's claims against you. The full amount of damages sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate.
And that's so strange. I mean, it is very weird. It's not that he couldn't sue the Department of Corrections. I mean, he certainly could. But these are his appointed counsel for the purpose of a criminal trial. They are appointed to get ready to defend him in a criminal trial. And now they've got like this for-profit thing they're doing over here where they're going to sue civilly the Department of Corrections. And it's like, why are you creating this conflict for yourself? Because what if you discover information? I mean, you might think, well, why would it be a conflict? What if you discover information in the process of preparing your civil suit? Say you've got like a $10 million damage civil suit against the Department of Corrections, and you discover something that would help his defense, but somehow undermine the civil suit. And now you've got, oh man, we got $10 million over here, of which we'll get $6 million. And we got this thing we've been appointed to do, the criminal case. We should do the right thing and go to the criminal case. But the whole reason you want to avoid conflicts is not because people are corrupt. It's to avoid the temptation to have divided loyalties and not to be totally on board with your client. So the fact that they were doing that, the fact they didn't see the potential problem there is just, once again, like, what are you thinking? So there's that. Then they talk about something we've talked about before, which is this is not the first leak of confidential information. The judge goes on. May of this year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product. And I think it was an outline that you created for yourselves with the discovery. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with the court. It wasn't shared with you, talking about McClellan, I think. Or no, talking about Rosie. This is another. I said Rosie did this in an earlier episode. This is actually Baldwin did this again. This was Baldwin's first leak of information. Wasn't shared with you, although apparently you guys knew about what was going on. And Baldwin says he didn't know. And the court says, you knew. And he says, I did know. So then Mr. Woodhouse gets arrested, and here we are, grossly negligent to email that to the wrong Brad. So basically, Baldwin is trying to send Brad Rosie a bunch of information about their case, the kind of thing you don't typically share with third parties. And he accidentally sends it to another client of his who'd been arrested for something else. So this is sort of the first leak of information. And rather than doing what they should have done, which is immediately go to the court and the prosecution and be like, hey, we had this breach. We've taken steps to avoid it happening in the future. We've, gotten the information back, whatever you need to do. I mean, that would be the appropriate thing. They just don't mention it to anybody. And it doesn't come out until later when I think that information gets in the hands of some other people and ends up on the internet. I forget exactly how it all came out. But nevertheless, the judge is pointing out, when you had the first leak, you didn't come and tell us that this had happened. The next thing, so the judge isn't done. It just keeps going. And this one, I'm so glad the judge talked about this, because when it happened initially, this is when, if you guys go back and listen to our legal briefs, when these people were first appointed, we did an episode on it. And we said, these guys look like they'll be good. They got a lot of experience. I think they'll be able to handle it. This should be a good defense team. I think this is going to make sure he gets the best defense possible, also moving the case forward. We've never been more wrong than we were in that episode. But we talked about that. The time when things started going sideways for me was when they filed the prisoner of war filing about how he needs to be moved to a jail because in the prison he's being treated worse than a prisoner of war. And the judge brings up that the pleading about the conditions was, to put it mildly, misleading. And here's what she says. Your pleadings on the safekeeping order contain inaccuracies and falsehoods. That was proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims, and that was very troubling to me. Now recall, the arguments made by the defense in the detention motion to move him weren't just vigorous representation or even arguable interpretations of the facts. They were out and out lies. They were supported by fake photographs presented as representing a Richard Allen being held prisoner in a prisoner of war type situation. Conditions where, he's not eating, he's barely being fed, and he's dirty, and he can't bathe, and all this other stuff. When in fact, the photographs they were using of him were in his workout shirt. So they were like his workout clothes. And they made it seem like that's what he's wearing all the time. And it's just terrible conditions. And that is something, when you put that in a filing, I mean, that's a huge issue to mislead the court. Candor with the court is something that all attorneys, prosecutors, defense attorneys are bound to do, because the system can't work if we're lying to the court. It can't work. And I think one thing that's really important to note, those improprieties, and really several of the ones we've talked about, involve both of them. So Brad Rosie can talk all he wants to about, I didn't know anything about the leak. He was involved in all this. He was involved in that filing. He was willing to mislead the court to get Richard Allen moved closer to him. That's what he was willing to do. And that has had a detrimental effect, frankly, not only on the case, but on public perception of this. You see people to this day talk about how unfair and terrible and horrible it is. Woe is me, an innocent man in prison, as if any of that has anything to do with the reality of the situation, which is he is, as the judge points out, in fact, being treated better and in a better situation in this place, in a safer situation than he would be in the county jail. So whatever you think about Baldwin and the leak, it's not just him. He is not the only one who's involved in these improprieties.
And that's why the judge starts with kind of all these things that are building up. She's essentially saying, look, I've given you a lot of grace over and over. Each of these individual things have given me a lot of concern because you have done things that violate your professional rules of, responsibility and ethics here. Now, kind of in totality, this is all topped off, we finally get to why kind of we were going to have this hearing, and that's the leak. This, and she goes on to say, and I'm going to read directly from the transcript here because there's some back and forth that's very telling. The state provided you discovery. That has been severely compromised. We now have an ongoing investigation. I'm not going to call it a criminal investigation. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You've had an attorney enter a written appearance this morning. I don't want to get into the investigation candidly. You are the constitutional authority for the state of Indiana. If you choose to pursue it, that is up to you. By the way, she's talking to the prosecution here. If you choose to abandon it, that is clearly up to you. And she's saying all this because that's right. The prosecution is separate from the judge. She then goes on to say, I'm glad to hear that you have cooperated, directing this at Mr. Baldwin. But Mr. Baldwin's attorney has clearly shared, I don't know if you've seen his pleading. And then Mr. McClelland, the prosecutor, says, I saw it, Judge. Yes, I got it kind of late. He emailed us, and then Judge Gull says, okay. And Mr. McClelland says, I saw that was filed on the way here. Remember, it was filed very, close in time to the hearing. And so Judge Gull responds, well, yeah, so he's clearly shared it in his pleading, down to the fact that an individual has committed suicide. He included the fact. Mr. McClelland then cuts in, I saw that was filed on the way here. Judge Gull then says, well, yeah, so he's clearly shared it in his pleading. Oh, wait. He included the fact that you left materials all over a conference room table. This is directed at Baldwin. Accessible to anyone. And this is a friend of yours who apparently you have consulted with on this case. So again, it's up to you if you wish to pursue that. I'm looking at the totality of circumstances. When I look at a suppression, the case law requires me to look at the totality of the circumstances. And that's what I'm doing. And it pains me to say this, but the totality of these circumstances demonstrate gross negligence and incompetence on the part of the defense team. I am unsatisfied with your representation of Mr. Allen. I am gravely concerned about his rights to have a competent, non-negligent representation. In other words, this decision is not based on the leak itself. She's saying, I am separating myself from whatever is happening in that investigation. That is up to the prosecution. Whatever they want to do, I'm going to have no part in it because that's proper. Remember, because of the separation of powers. The prosecution executive branch is separate from the judiciary. The judiciary should not influence what the prosecution decides to bring charges against or to drop against. The judge is just supposed to review what is before her. And that's what she says here. She makes it very clear. This is not just about the leak. The leak is part of this totality of circumstances that includes the entire defense team, Rosie and Baldwin. And she makes the finding that there has been gross negligence and incompetence by both of them, not just Baldwin. Because again, this is not based on the leak alone.
And now that she's shared this with them, she puts it on them. Like, so what are we going to do here? And she says, I want him to have non-negligent counsel. And she says he doesn't have that right now because what you have demonstrated is negligence and incompetence, which is harsh. But I mean, she's telling him like she sees it. Now, I'm sharing my thoughts with you privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It is not where we need to be with this case, but I will. But you don't know that. You have just now been made aware of my concerns and where I'm landing. So if you wish to have a private conversation, I would encourage you to do that. I don't believe your client is here yet. No, he's not. Clearly, you'll need to speak with him as well. So, and then Baldwin says, I'm not good at reading between the lines, which you must be really bad at it because there's not much reading between the lines required. And then the judge says the funniest thing that's said in the entire proceeding. You're a lawyer. That's what you do for a living. And then Baldwin says, when you say have a private conversation, are you talking the four of us or the court? I'm talking about you. I'm not accusing the state of gross incompetence and negligence. I am finding gross incompetence and negligence with you. So at this point, the judge has basically said, if you want to have this hearing, this is where I'm landing. This is up to you. Do you want to have the hearing or not? You need to talk to your client. You need to talk to Brad. Y'all need to figure this out.
And best friend that everyone should have, Rosie, tries one more time to gently throw Baldwin under the bus. He does not come off great in this transcript. So then Rosie says, I mean, obviously, reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. Is there a scenario where the court would accept if I stayed in the case? I mean, I'm a team player, and I'm not the kind of guy that just bail out on somebody just for the sake of doing it. But I think it's obvious that, he can speak differently. But I'm not as connected to some of, this most recent circumstance as he is. Man, I can't see Baldwin's face in this situation.
What
But
a
if I were
team.
Baldwin, I would be like, what the heck? Because if you heard what Judge Gull said, clearly the finding of gross incompetence and negligence was against both of them. But here Rosie's like, look, this last leak, still nothing to do with me. I'm not trying to throw him under the bus, but seriously, it's all about him. So what if I just stayed on? And this is important because it seemed like a lot of people, after the meeting was like, well, what about Rosie? He didn't do anything wrong. And he actually addresses this and he tries to stay on in this hearing, which is why when he files something later where he's like, I had nothing to do with this, I was completely, ambushed, is not right because he already had this discussion with the judge in chambers. So Rosie goes on to say, Mr. Allen is in a situation where he's going to have counsel that's, if he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment rights matter. And, I'm probably the one that can at least move this thing forward with some sense of judicial economy. I don't like it, and that's not what I intend to do when I came in here. But that would be kind of a worst case scenario on our side, I guess. So is that an option that the court would entertain? Very clear question. Can I stay on to help transition or to make sure that Richard Allen has representation? And Judge Gull responds very succinctly, no. Nothing else. I mean, it could not be more clear. She's like, no, absolutely not. So Mr. Rosie then goes on to say, so basically what you're saying, I'm chuckling because I love how he's like, I'm reading the tea leaves. What you're saying is, if I'm reading this correctly, I'm like, the judge could not be more clear. She gave you a one-word answer. The answer is no. So he says, so basically what you're saying is you guys either quit on your own accord or you make me fire you. That's what, and the court says, no, I'm saying to you that this is what I plan to say in court on the record when we convene at 2:00. Mr. Rosie says, well, so is the culmination of that you're removing us from the case? And Judge Gull responds, I will, based on what I've just shared with you. And Mr. Rosie responds, okay, well, I just want to make sure and Judge Gull says, and I'm just giving you the opportunity to have a conversation, which how do you want that to go? I don't want to do this. I don't want to do this, but I will if I have to. Mr. Baldwin then steps in and he says, should we bow out gracefully, as Brad says? How would we even have a hearing? How would that go? Because if we're out of the case, then, and Rosie says, then you're going to go ahead and rule on a bunch of stuff without lawyers in the room. And Judge Gull cuts him off. No, I would not do that. If you decide that your best course of action is to file a motion to withdraw, you can do that today. And I'll send Mr. Allen back to the DOC after you've had a chance to speak with him. And Mr. Baldwin responds, would that happen before the hearing or after the hearing? And Judge Gull says, your motion to withdraw would happen before the hearing. And Mr. Baldwin responds, okay, that's what I wanted. Yeah. And Judge Gull says, yeah, because he has rights and I don't want those rights compromised by having a hearing with him not having counsel. I assume if you choose to withdraw that his financial situation hasn't changed and he would still be entitled to court-appointed counsel. I can't imagine that he has the ability at this point to hire counsel. I don't know that. And Mr. Baldwin responds, Brad and I need to talk. And Judge Gull said, yes, you do. Thank you, gentlemen. And Mr. McClelland says, yep, thank you, Judge.
So at this point, Baldwin and Rosie go speak to Alan. Alan hasn't been present in this hearing. Sounds like from discussions later on that it's basically the policy of the Department of Corrections. They're not going to let someone who's accused of these sort of serious crimes in the chambers with the judge. Different places have different rules about that. I've certainly been in chambers with the judge. You know, I think it just depends. It just depends on sort of what your rules are, what your safeguarding procedures are. So he's not in there. I don't like that. I wish he'd have been in there for the whole thing, but his lawyers are in there and they're about to go talk to him about it. So they go and speak to him. They come back and they basically say, look, this is all on very short notice, but Richard Allen wants us to stay his attorneys. And they're candid about the limits of Allen's ability to keep them on the case under the constraints of the law, which is something we have been talking about for weeks. But they say he wants us to continue with his representation. He understands, I think, that he's not the gatekeeper, or he doesn't have the authority to really force the court to do that. He would like to say that on the record. We have been telling you this for a couple weeks, that as appointed counsel, because he's indigent, he doesn't actually have the ability to keep them on the case. Rosie and Baldwin understood that at that moment. They obviously are now arguing something different because they want to change the law. They want to have a new law in Indiana that would allow them to stay. But that is the rule. And whatever you want the law to be, that's what it is. And they understood that at the time. And they had advised their client correctly in the moment that not really up to him given the circumstances. So they want to put it on the record. But, you know, his counsel are concerned about having him speak on the record, given that he is an accused murderer. I think this is interesting because I think this goes back to the fact they don't want to have this in open court. They don't actually want that to happen. And he's wanting to put this on the record, and they're like, oh, well, you know, we wouldn't want him saying anything. Clients occasionally have to speak to judges on the record that have nothing to do with the crimes of which they are accused. So I found this to be a little disingenuous, but nevertheless, that's what they say. So Rosie says he's going to file a motion to withdraw, but he argues that he should have had more notice of what is coming. And this sets the stage for what you're going to see sort of in the mandamus petitions, which is essentially Rosie saying, if you were going to do this, you should have given us more notice. As we talked about, they had several weeks. I think what he's really saying is there should have been more formal notice. We should have known ahead of time in some sort of formal way that this was going to happen. I'll read. It's a rant. I mean, he goes on quite a rant. I'll read some of it to you. He says, I'm going to file a motion to withdraw. I don't want to do it, but I don't think that I have a choice at this point. The options I've been given without any notice by the court really are either I withdraw, or I'm going to be publicly shamed, and that's the way I see this. And I think that public shaming is there's not only a professional element to that, I think there's a personal aspect to that too. But when the media is teed up like this, and, you know, we show up here today with the court having told us that we were going to conduct some business, that somehow bleeds over into a forced resignation or whatever you want to, however you characterize this. You know, I don't feel like that I have any other choice professionally. I have a life beyond the courtroom and beyond this case, and I have a family too, and I have a law practice. But I think had we been given some notice of what we were actually, if this would have been framed in a pleading format or some formal disciplinary claim, which there's a process for that in our business, then we could have come in here today with an opportunity to refute some of these things that you clearly had, you know, thought through and prepared before you got here. And we didn't have the opportunity to do that. The idea that I'm going to have to go in there in open court and essentially defend myself against claims that I don't agree with without any notice, without any opportunity to think is unfair. But I have also some common sense. And, you know, me going in there and standing my ground because my client wants me to is just going to make things worse for him. And so I'm going to withdraw my appearance. This is a moment of clarity for Rosie that he very quickly lost, that is actually in his client's best interest to go ahead and get this over with. I'm going to walk out of here. I'm going to go down to my car. I'm going to call my staff and have them prepare a motion. I'm going to withdraw my appearance, but I'm doing it because I don't think I have any other choice professionally, not because I want to and not because my client wants me to. And I respect the court has an opinion, but we're professionals and we can disagree. The court says, of course. And, you know, I'm extremely, you know, I'd say frustrated, probably a soft word, with the idea that we showed up today without any real opportunity to prepare for any of this, like, I don't know, hiring an attorney and filing a memorandum on it. And I just think it's improper, and that's where I am. And that's my position. And this is sort of, he staked out the position they're going to take going forward, which is we should have had more notice. This should have been more formal, even though we don't actually want to have a formal hearing. We want to have some sort of hybrid private hearing where we can do this. And that's his position.
And I'm glad that the court kind of steps in here and notes that, kind of calls him on that lack of notice allegation that is just false. Because the court says, no, you were on notice, even if Rosie thinks it wasn't formal enough. So the court then goes on to say, well, I think we talked about when you asked for a disqualification, and I indicated on our phone conversation I'm inclined to do that. Mr. Rosie said it was a phone conversation that was not on the record, and then some follow-up emails. The court said, true. Mr. Rosie then said, there's an informality to that. The court responds again, true. Now, Rosie notes that the prosecution didn't formally move for their disqualification, and the court tells him that she's doing it on her own notice, which she's allowed to do. It's in the discretion of the court to do so. And Rosie kind of waxes poetic for a while about how he doesn't like that he's being given a choice between public shaming and being disqualified. It's not like the public shaming is not due to his own actions, right? This is my problem with his protestation. Is he's like he's putting it yet again on anyone but himself, right? Oh, the court of the clerk accidentally filed the Frank's motion publicly. That's their fault. You're gonna publicly shame me. That's why I have to do this. No. Everything in the public shaming, if that's how you're going to frame it, is a finding of fact by the judge based on your actions. So if you want to frame that as a public shaming, go for it. But it's not like she got up on the wrong side of the bed and decided today was the day she was going to give an attorney a tongue lashing, which, by the way, judges do all the time. I get publicly shamed all the time by judges, and not because of facts, because the judge just doesn't like the way I look that day and woke up really angry and didn't have a cup of coffee. They're allowed to do that. So it's a complete mischaracterization to call it a public shaming, especially when the prepared statement I thought was very fair. It was rooted in fact. It quoted from the transcripts of previous hearings and previous things said by Baldwin and Rosie. And it was not superfluous, flowery language filled with emotion. You heard her read it previously. But anyways, I'm getting a little bit down a rabbit trail and we've already gone past an hour. So Baldwin has been quiet through a lot of this, but for his part, he does thank the court for letting them have this meeting and saying that he, quote, appreciate giving us the advance notice. As he should, because this was going to be all done in open court for all to see forever and ever and could be career ending. So at least he has that moment of clarity and recognizes, thanks for doing this for us, Judge, because as terrible as this is, at least this was not in public. Until, of course, the defense causes all of this to be released, which is what we're now reading. So Baldwin doesn't give this soliloquy about every action he's going to take, from the number of steps he's going to take to his car to how he's going to call his office to file motions. He does something more straightforward. He just says he's moving to withdraw orally. And Baldwin asked for the court to wait till they get out to announce their withdrawal. And the court agrees to do that for them, again, to save them face.
And probably the person I felt the sorriest for was James Luttrell. I don't know if anybody who read the transcript knew this or noticed this, but you got James Luttrell, who at the very beginning of the thing is like this new lawyer who's come on. I think he might actually be an old lawyer who retired and joined the prosecution team, but it's his first time appearing on the case. He shows up at the beginning, and then at the end, the defense attorney's like, well, it was nice to meet you. And he's like, yeah, nice to meet you too. And I could just imagine what it was like for him to sit through this whole thing as it blows up on all the defense team. So anyways, I thought that was humorous. So that's the end of the transcript. As Alice said, we've already gone an hour, but we're going to talk for a little bit longer.
Do we want to just make this a second episode?
Honestly, I would rather not talk about Delphi next week. So I'd like to just wrap it all.
Well, it would just be tonight.
Just wrap it all up. Well, whatever. People listen. They love things like that.
All right. Sorry, guys, for going so long. So much.
Do
for
any
brief.
of you mind that we're going so long? None of them mind. So, okay. So just some questions about this that people have asked us since this has been released and everything else. And one of them, the big one, is what is the Indiana Supreme Court going to do in this case? And the simple answer to that is who knows? Who knows? This is whenever things get in front of a Supreme Courts can do things that don't necessarily follow the law as you've seen it. That's one of the things Supreme Courts do. Now, in our episode from a few weeks ago, we laid out the United States Supreme Court jurisprudence on representation on the Sixth Amendment, and under it, Richard Allen loses. Just all there is to it. If you've read his mandamus petition, he barely mentions the Supreme Court, and there's a reason for that. And as we talked about, we cited this case, Kaplan versus Drysdale, Supreme Court case, which makes it very clear petitioner does not, nor could it defensively do so, assert that impecunious defendants have a Sixth Amendment right to choose their counsel. Guarantees defendants in criminal cases the right to adequate representation, and that's it. And that's a big problem for him. So instead of relying on Supreme Court jurisprudence, he's relying on what I think you could term as the minority position, which is a position that a few states have taken, and they're allowed to have sort of a higher floor than the Supreme Court sets for what a defendant's rights are. And, they have their own constitutions. For instance, there's a California case that really underpins this. It's called Smith versus Superior Court of Los Angeles County. If you've read the mandamus petition, you've seen this case cited multiple times. This is a case from 1968. But here's what a 2018 California case says about that 1968 case. In a more recent decision, the defendant does not cite, however, you can almost imagine that being written about Richard Allen's mandamus petition. Our high court ruled that to the extent that the holding in Smith and in 3 other decisions were based on the federal constitution, they have been superseded by the Supreme Court's decision in Wheat versus United States, which if you listen to our episode, we talked about a lot. Further, in Jones, the California Supreme Court squarely held that when a trial court removes a defense attorney because of a potential conflict of interest, the court is seeking to protect the defendant's right to competent counsel. In such circumstances, there is no violation of the right to counsel guaranteed by the state constitution. Thus, Smith is no longer good authority. So you have a California Supreme Court opinion that says that one of the key cases that Richard Allen is relying on in Indiana, in the hopes that the Indiana Supreme Court will adopt that position, is no longer good law. That's the kind of thing that makes it hard to succeed when you're arguing in Indiana courts. Now, if you want to, you can read what the state has said and what Judge Gull has filed. There are 2 filings in this case. You may remember in the first mandamus case, the state, they said, we're not going to bother responding to this. The first mandamus really didn't have any issues to implicate the states. They didn't care whether or not certain documents in this case are public or not public. But once you start trying to expand the ability of defense counsel to stay on cases when they probably shouldn't, then the state's going to have an interest. So the state came in and they filed their own reply. I would like to think it sounds a lot like what we've said in the past, cites a lot of the same cases, cites Slappy, for instance, which is a great case, a great case name, and sort of lays out the same type of thing that we talked about. It makes a couple really what I thought were great points. I mean, number one, it talks about how there's not much of a record here because there was no hearing, and it points out that the reason there's not a hearing is because the defense counsel declined to have one. It also points out that the Indiana Supreme Court has never ruled on this particular issue. Normally, that might be problematic. You like to be able to say the Supreme Court has ruled on this and they ruled in our favor. But a mandamus petition, you have to show that what you're asking for is clearly something you should get. And when the Supreme Court's never addressed the question before, you can't show that. It's very well written. I thought the state of Indiana's response was great. Judge Gull's is a little bit more directed at these 2 attorneys, I thought, and really kind of pointing out all the things they did. I thought the state of Indiana's response is probably going to be more effective in court. Judge Gull's, I thought, was more of an effective, maybe defense of her, whereas, the state of Indiana doesn't care that much whether you think what Judge Gull did was proper or not.
Which makes sense, right? I mean, she's like being personally attacked and being dragged through the mud in these filings about her biasness and whatnot. So it makes sense where her position is coming from. So there's still a lot to talk about because was there a due process violation here? On several occasions, the defense mentions due process. You heard it in the transcript from that meeting in chambers, and also, as they've done on multiple occasions, the former defense counsel keep talking about due process as if it is the lawyers rather than Richard Allen whose rights are at stake. Now, due process usually requires notice and an opportunity to be heard. But how much notice is required, and how formal does it need to be? The defense here had 2 weeks' notice that disqualification was on the table. That's why they wanted the in chambers meeting, because this was about disqualification. Remember, again, Baldwin hired an attorney and filed a brief directed at why they should not be disqualified. So they certainly had notice of what was about to happen. So that's not an issue here. It's not about notice. Well, what about an opportunity to be heard? Because that's the second part of due process. The defense could have availed itself of that opportunity. A public hearing was scheduled, but they did not want that to happen. In fact, to the extent they wanted a hearing at all, they asked that it be ex parte, meaning without even the prosecution there, and in private. So even more private than the meeting that occurred. At no point do they ask for a continuance, which means to delay the hearing, so that they can prepare for a public hearing. That's very common, by the way. Oftentimes, if you have late found evidence or a newly raised argument, you can hear argument in court that whatever side wants to respond will say, well, Judge, that's a really good question you've raised, but we were planning to address points 1, 2, and 3 that you stated in your order setting this hearing. You're now raising point 4, and we just aren't prepared to discuss it at this time. We'd like to take the opportunity to fully brief that and have a continuance of this hearing to continue that discussion. That would be the proper thing to do. I've done that multiple times in court. When something kind of new arises and I'm like, you know what, I need to research that. I need to kind of really look into it and not just go off the cuff here. They had the right to do that, or at least to ask it. The court could always deny them the opportunity to have a continuance, but it wasn't even raised here. So there were proper procedures to be followed here that they didn't avail themselves to. Now, they also complain about the suddenness of everything that was happening, but they also say in that same breath that they have no interest in a public hearing that day or any other day. And the fact a public hearing would have been embarrassing or a public shaming, as they say in their words, is really not legally significant. They don't want a continuance of this hearing because they don't want any of this to be on the public record ever, whether it's today or later. And you don't have a right to not be embarrassed in court by a judge. Truly. If you did, like every lawyer in America would have a cause of action. I would have cause of actions left and right because I'm embarrassed by judges like on a daily basis. It's just like I wake up and I'm like, which judge is going to decide to embarrass me today? That is not a cause of action. That is literally just a rite of passage if you enter the bar. So you might be wondering, we've talked about lawyers. What about Richard Allen? Isn't he entitled to a hearing? Now, his lawyers appear to only be concerned about themselves and due process for themselves. So can they waive his right to a hearing? Now, this is a good question. And it's rare to have a situation like this because it seems like they can waive a hearing for him. In Merca versus Fairfield of America, Inc., which is a case out of the Indiana Court of Appeals from 1994, that court said, quote, in the absence of fraud by the attorney, the client is bound by the actions of his attorney, even though the attorney is guilty of gross negligence. What we have here is the judge making a finding of gross negligence against Rosie and Baldwin, yet Indiana's, a Court of Appeals opinion says that even with a finding of gross negligence, unless there's fraud by the attorney, doesn't matter. The attorney still represents the client, and the client is bound by what the attorney does.
So then you have the question, was the withdrawal technically sufficient? And this is sort of an underlying current in this sort of formalism versus realism that you kind of see going on here. So Rosie raises it in the hearing and talks about formal notice. Like, well, we had notice, but it wasn't formal notice, right? As if, all of this would have been solved just by the judge putting a notice out that said, on this day, we'll discuss whether or not the defense counsel should be disqualified. And then because it was a formal notice that gave them the exact same information they already had, well, that would be good enough. But it's not good enough that you actually knew it. Generally speaking, formalism has fallen out of favor almost entirely. There used to be a time where courts were much more formalistic. And what I mean by that is the substance mattered less than the form. And the form really mattered. I mean, think about like a contract, right? Like you fill out the whole contract, there's a meeting of the minds, and there's a signature line, and you don't sign it on the signature line. You sign it on the bottom of the page instead of the top of the page. And 150 years ago, the courts might have been like, aha, you didn't sign it on the signature line. Therefore, contract is invalid. And now it's like, no, was there a meeting of the minds or not? Did you have an agreement or not? If you did, we're going to treat it as binding, and we're going to hold you to the contract. We're not going to let you out of it because of some technicality. It's the same thing here with sort of the formal versus the informal. Did they have notice or not? Did they know they were walking in there and disqualification was on the table or not? Did they know what the issues generally were or not? And that's really the question. And it's the same thing here with this technically sufficient withdrawal thing, which you see people raise. So people have pointed out that sort of the Indiana rules of professional conduct and the rules as to sort of court procedure may invalidate the withdrawal because they require 2 weeks notice and they require that the withdrawal be in writing. Now, the point of this rule is to protect a defendant from being abandoned by his attorney. You can't just decide to quit on your client. You got to give them some notice. You have to make it formal. That's not what's going on in this case. In this case, the court was prepared to remove both of them on their own motion. And the court says that, like, I'm doing this on my own motion. This is just sort of allowing the defense to withdraw on their own to sort of avoid that embarrassment. So does that somehow invalidate what the court did? Well, assume it was procedurally flawed. Assume the court shouldn't have done that. Well, then you think about what's the remedy, because remedy matters too. And the remedy isn't always, well, I guess they just have to be back on. Well, all of that just goes out the window. Doesn't matter that they were negligent because the judge violated Rule 3.2 of the trial rules or whatever. No, the remedy would either be for the court to simply go ahead and remove them on its own, which essentially the court did that in this October 31st hearing where they'd show up again. Rosie and Baldwin show up again and sort of make some half-hearted effort to stay on the case. And the court explains, I'm not going to let you do this under any circumstances. So that would be one thing the court could do. Or any challenge to the removal that they now want to raise is actually invalidated as invited error. So you have a rule that says when the person challenging what happened invited the error, said, let's do it this way, judge. And the judge says, okay. And then they turn around exactly like happened in this case and say, ha, the judge messed it up. True, we told him to do it that way, but now we're going to challenge it. You can't do that. The law is not stupid, is something I like to say, and that would be stupid if you could do that. So I think it is highly unlikely that the Indiana Supreme Court, is going to find this to be a compelling argument. You never know with elected Supreme Courts, but I doubt it. I doubt that they're going to say, that means Rosie and Baldwin are now on the case for all eternity, and it doesn't matter what they did.
And especially with the invited error, kind of that doctrine is very compelling, right? Because at root, what we're trying to say is we're just trying to get to justice here. We're not trying to do a gotcha. You signed on the wrong line, you used the wrong, font. That's not what's here. And if it weren't for this transcript being released, the invited error about what has happened would not be so clear. So again, the release of this transcript just makes it completely clear that this was all at the behest of the defense counsel, who are now complaining about the manner in which this was executed. It was at their request. All right, we're honing in, guys. Stay with us. We have one last topic, because remember how there was also a pro bono filing. So we had told you in previous episodes that there are different rights for retained counsel versus appointed counsel. And in what we think was an attempt to somehow gain the protection of retained counsel, Rosie and Baldwin kind of turned around and offered to represent Alan pro bono. Now, will this succeed? Think about what it would take for this to succeed. First, the Indiana Supreme Court would have to endorse what is a naked attempt to circumvent the trial court's ruling. Second, the Supreme Court would have to do so even though Baldwin and Rosie have made no showing that they can afford to represent Allen competently without resources. It's not just their time, right? It's not just the billable hour or what have you. There are experts who cost tens of thousands of dollars, if not more. In a case like this, like a simple, easy peasy case, you can easily drop $30,000 to $50,000 on an expert to talk about a civil case on damages. For something like a criminal trial of a double homicide, and you're going to talk about maybe blood, maybe blood spatters to the gun being discharged from, sorry, the bullet being discharged from the gun versus all these different experts you could have. We're talking hundreds of thousands of dollars of expert opinion and expert testifying opinion as well. They haven't shown that they can afford that themselves. And there were already rumors that the representation was putting a strain on both men's finances, and that's without doing it for free. Maybe they could afford a pro bono litigation, but they simply haven't shown that. And third, the Supreme Court would have had to find that the reasons given for removing Baldwin and Rosie weren't sufficient. Remember, this is not a case where the court arbitrarily removed appointed counsel just because she woke up on the wrong side of the bed. She clearly stated, as you can read in the transcript, that she removed them for cause, and she has the discretion under the law to do so. Even if the pro bono action has some effect, the question still resolves back to the merits. Does a trial court have the discretion to remove counsel for gross negligence? The answer is yes. And the best evidence that this pro bono filing has no real legal significance doesn't come from what we're saying. It doesn't come from what the judge says in her filing. It doesn't come from the state of Indiana's filing in response to the writ of mandamus. It comes from Allen's own mandamus petition because the defense doesn't even bother to make this argument about pro bono.
And that tells you
Silence
all
is
you need to know.
deafening. Yeah, silence is deafening.
Yeah. If the new lawyers who did the mandamus thought that had any chance to succeed, they would have made that argument. They didn't. So, yeah. I mean, people bring that up, but yeah, I mean, there's no answer to it. Like, I can't point to a case for you on that because I've never seen anything like this. I mean, the idea that you would be removed by a judge in these circumstances and not just leave, it's hard to imagine, but that's where we are. And that was long and that was a lot, but I think that covers just about everything. I'm hoping that we're done with Delphi for a while. Presumably,
I'm hoping we've poured cold water, at least, on these filings and the transcript, that there's nothing to see here. Like, there just isn't. And for the sake of Richard Allen, Baldwin, I think, was it Rosie, who said in the transcript, "Can I stay on for judicial economy?" This is the opposite of judicial economy. This is wasting the court's resources. And I don't just mean Judge Gull. I'm talking about the state of Indiana and talking about the Supreme Court. And it is wasting time for Richard Allen as well. He is not better off because of this sideshow circus. So it's time that they step back and kind of accept what the law requires here.
And just as a matter of, these lawyers have proven that whatever they are not the only people in Indiana who can represent Richard Allen. This is not a case where Richard Allen is not going to get a vigorous, competent defense unless it's these two guys. And this is just, as Baldwin said, this doesn't have anything to do with Richard Allen anymore. This is all about them. He didn't mean it that way, but that was a moment of truth. And I just really hope the Supreme Court of Indiana just squashes this. I hope they do it in like a 3-sentence opinion and we move on. I mean, if it's interesting because the state of Indiana, the Attorney General's filing kind of points this out, that Rosie and Baldwin complain about the lack of a hearing, but once again, even in the mandamus petition, they're not really asking for it. Like, that's sort of the only thing I could imagine the Supreme Court doing, is sending it back for a hearing, but they don't even really ask for it. So, I think, number one, I can't imagine a circumstance in which the Supreme Court just reverse Gull and put them back on the court without some sort of hearing, or back on the case without some sort of hearing. I just can't imagine that. That doesn't even make sense, because then I think she could probably order a hearing, unless the Supreme Court made a very strange ruling in which it was like, you can never remove them. Like, they're back on the court or the case, and you can never remove them. I don't think they're going to do that. So if they come back, best case, I think there's some sort of evidentiary hearing. As I said, I think when we talked to Murder Sheet, I think what they're hoping is they'll also remove her from the case, send it back for an evidentiary hearing that a new judge just doesn't even bother to do. And that is, I mean, maybe they'll shoot that gap, but we'll have to see.
I've used all my words I can, at least for this
All your
week on
words.
Delphi. We're done.
We're done. Well
I
done.
hope
We're
so.
done.
I hope so, at least. Well, I mean, I really hope that this is clarified, or like we said from the very beginning, you guys don't need us. You can read these filings yourself. We've, tried to stick with straight what the transcript says, what the filings say, and not, kind of shade them for you. But of course, it's our point of view. So go read these filings for yourself, and we'd love to hear from you. If you have any additional questions, please write to us at prosecutorspod@gmail.com. Reach out to us on social media. We're on X, formerly known as Twitter, Instagram, Facebook. We have a fan-run Facebook group, The Gallery, where a lot of awesome discussions happen, including about the Delphi case. So with that, Brett, is there anything you'd like to add before we sign off for the day?
I've said enough, Alice. I'm done.
Wonderful. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.